a number of bills today, but I'm going to let you know what bills have been pulled and which ones are on consent. So if you're here on those bills, you can either consider your day done or stay for the fun. We have the following bill that has been pulled from today's agenda, which is file item 11, AB 998 by Assemblymember Wagner. That bill has been pulled. It will not be heard today. Additionally, we have a consent calendar of 3 items. Item number 4, AB 506 by Mainshine. Item 14, AB 1097 by Holden. And item 15, AB 1107 by Assemblymember Irwin. Those bills are on the consent calendar. We will turn to our daily file, our agenda. It looks like we have a quorum, so I'm going to go ahead and establish a quorum.
Jackson?
Here.
Jackson here. Morlock? Morlock here. Anderson? Hertzberg? Leno?
Here.
Leno here. Monning?
Here.
Monning here. Wykowski?
Madam Chair, if I may, move the consent calendar.
Absolutely. Motion by Senator Leno to adopt the consent calendar. Please call the roll.
Jackson?
Aye.
Jackson, aye. Morlock? Aye. Morlock, aye. Anderson? Hertzberg? Leno?
Aye.
Leno, aye. Monning?
Aye.
Monning, aye. Wykowski?
All right. That consent calendar has 4 votes. We will keep it on call for the absent members. I'm told that we will have Senator Hertzberg coming shortly, but we are going to go ahead and start. And our first item in file order, which is how we call the calendar here, the first item is Assemblymember Holden, AB 15. If you'd step forward. The rules of engagement here are that for each bill, we ask that there be 2 main witnesses, 2 minutes each for support. After we hear from those 2 witnesses, 2 minutes each in support, we will ask those who are also in support to line up. And we have 2 microphones, one on either side of the dais, where you can indicate your support for the bill. We'll then ask those in opposition, 2 witnesses, 2 minutes each, to indicate their positions, and then ask the opposition at that point in time, any additional opposition, to also come up to the microphones just to provide your name, your affiliation, and obviously your support or opposition for the bill. So with that, Assemblymember Holden, good afternoon. Please proceed.
Thank you, Madam Chair and members. It's a pleasure to be here with you this afternoon, and I'd like to thank you for the opportunity to present Assembly Bill 15 relating to human rights abuses. When victims of torture, war crimes, trafficking, and crimes against humanity file cases in state court, they must assert tort claims such as wrongful death, assault, or battery. In California, these human rights abuses carry a 2-year statute limitations, which is often not enough time to gather information and evidence to ensure victims of abuse get a fair trial. Survivors of this abuse face unique obstacles to bringing their suit, and it often takes many years for them to find their way out of the perilous circumstances. For these victims, 2 years is too little time. AB 15 extends the statute of limitations for human rights abuses to 10 years, aligning the time limit for filing claims in California with current federal law. Additionally, this bill would revive eligible claims, finally allowing victims of the Holocaust, Armenian genocide, and other historic incidences of egregious human rights violations to seek a remedy for the abuse they suffered. The committee proposed amendments that would remove the revival claim, but I believe that victims should not be denied access to justice. The committee analysis speaks at length about the crime of murder, and that murder does not have a limitation on the time to bring a claim. For some victims, to debate the difference between torture and murder is a blur because of the amount of suffering they have experienced. California is one of the nation's top 4 state destinations for human trafficking. I believe that finding a remedy for any human rights abuse should not be hindered by seeking justice. The result of most of these cases goes unheard, allowing even the most reprehensible abusers to escape justice simply because time is on their side. AB 15 aligns California law with federal law and allows victims to pursue closure for the atrocities they've experienced. I respectfully ask for your aye vote.
Member, two witnesses, 2 minutes each.
Chairperson Jackson and honorable members of the Judiciary Committee, my name is Amanda Werner, and I represent the more than 30 human rights, religious, labor organizations supporting this bill. As the sponsors of AB 15, we must strongly object to the chair's proposed amendments, particularly the removal of any reference to Section 361. AB 15 at its core is a human rights bill with two primary objectives. The first is allowing survivors of genocide, torture, and crimes against humanity the opportunity to confront their abusers in court. But the second objective is ensuring that the most notorious abusers cannot escape justice within California's borders. The amendment to strike reference to Section 361 would defeat both central purposes. Let me demonstrate just how drastic the proposed amendment is. In our Assembly Judiciary Committee hearing, Florencia Molina shared her story as a witness to voice strong support of the bill. Flor was trafficked from her village just outside of Puebla, Mexico in 2001 and forced to work 18-hour days sewing dresses in a factory in Los Angeles. Her trafficker still lives in Los Angeles, not far from where Flor and her family now lived, and has never served a day in jail. California clearly has an interest in seeing Flor's trafficker brought to justice. But even though the majority of the abuse occurred within California's borders, Section 361 could bar Flor's case because her trafficking claim originated in Mexico. While Section 361 includes a limited exception for California citizens, it does not help the vast majority of survivors like Flor, who did not become California citizens until after they were trafficked here. As a result, if the committee removes this bill's reference to Section 361, it will not only deny the vast majority of those who have survived the most heinous atrocities the opportunity to finally confront their abusers in court, it will also deny California the opportunity to seek justice against the worst of the worst human rights abusers seeking safe haven within our borders. I understand the committee's concerns about forum shopping, putting a burden on the California court system, but personal jurisdiction and venue rules ensure that cases having no connection to California will not make their way into our court system already. Section 361 does nothing to bolster these protections. Instead, it prevents even the most meritorious claimants from being able to confront their abusers in court. While we appreciate the chair's recommendations, as human rights advocates, we cannot in good conscience accept the proposed amendment. Thank you.
Thank you. Next witness.
Chairperson Jackson and honorable members of the Judiciary Committee, my name is Haig Bagdasarian, and I'm the grandson of 4 survivors of the Armenian Genocide and the great-grandson of one of its victims. I'm also a former San Francisco Human Rights Commissioner, and I appear before you to testify in support of AB 15. My wife and I both grew up learning about the devastating impact upon our families, including the brutal murder of many of our relatives. Justice had not been afforded to the victims of the Armenian Genocide and their descendants, as well as those of the Holocaust and many other genocides and crimes against humanity. In the case of the Armenians, the devastation hindered the victims' ability to seek redress until the 50th anniversary of those horrifying events. The bill could help remedy the reality in a very meaningful way to a small but considerable pool of Californians. Senators, there have been some questions and amendment proposed regarding the retrospective nature of the bill. The reason for the retrospective provisions are that victims of crimes against humanity, which occurred in years past, have been no less harmed and should therefore not be denied the similar redress for wrongs inflicted upon them as would victims of more recent crimes. Our state law provides that owners of stolen artwork may seek legal redress up to 100 years following the theft of such works. Do we really place a higher value on stolen art than we do on the lives which have been destroyed, the resulting harm and frequent unjust enrichment on the part of perpetrators of such egregious crimes against humanity? Our laws provide statute of limitations for most crimes and torts. However, our laws also recognize the need to significantly extend the statutory periods, as in the case of looted artwork, or to do away entirely with such constraints, as in the case of the crime of murder. So how can we primarily force crimes that we hinder rights to seek redress for civil actions stemming from genocidal acts, which may be prosecuted in perpetuity. It's critical that members of impacted communities be afforded justice. Personally, I wouldn't benefit from the enactment of this law, but I stand behind the pool of applicants who would. The retroactive component is not an indefinite provision. It just creates the opportunity for what will certainly be a very manageable number of claimants to bring for their causes of action within a 2-year window. AB 15 is a very measured and well thought out piece of legislation and worthy of your support as it was drafted by Assemblyman Holden without amendments. Thank you for your time.
Thank you very much. Are there any other witnesses in support who would like to step forward and to give us their name, their affiliation, and the fact of their support? If you'd like to do that, we have microphones here. We'll give you a minute to come on up. Okay. And again, just name, affiliation, and obviously you're in support. You can say in extreme support or strong support, but just leave it at that if you would. Okay.
Hello, my name is Ani Hakopian. I am from the Armenian National Committee of America, and I am in extreme support of this bill. Thank you.
Thank you very much.
Hello, my name is Maral Margosian. I'm with the Armenian National Committee of America, Western Region, and I'm also in extreme support of this bill.
Thank you. We'll have this gentleman over here who's waiting patiently. Go ahead.
Hi, my name is Morris Sarafian, and I'm from the Armenian National Committee of America, Western Region, and I also support this bill.
Thank you.
Hi, my name is Sabine Arslanyan. I am an intern at the ANCA Western Region, and I also support this bill.
Thank you.
My name is Sadin Keosian. I am also from the Armenian National Committee of America, and I'm also in support of this bill.
Thank you very much. Anyone else in support? Do we have anyone in opposition? All right. We're going to bring it back to the committee, and I will start. First of all, I want to express my appreciation for the discussion. I sit, and we sit here as a Judiciary Committee and have to look at our system of justice, not only its substantive process, but its actual or its substantive aspects, but also its procedural aspects. And I can tell you I share concerns about genocide. I am Jewish. I lost a huge portion of my family during the Holocaust at the hands of the Nazis. I am not very happy about the fact that we know so many of those people escaped, particularly down to South America, where they lived out their natural lives. That being said, and I say that because I completely understand and share that concern that we want justice, but justice is as much a system. And my concern about going back 115 years begs the question, why do we have these statutes of limitations? Why do we say in particular crimes that you have to bring the complaint, if you will, within a certain period of time, within a certain number of years? And part of the reason is to make sure that the evidence, the opportunity to have justice done, is done in a way where the evidence is fresh, where recollections are not diminished or are not misconstrued because of the passage of time. So my point is that we have statutes of limitations, we have regulations, we have jurisdictional requirements in order to make that system of justice work as best as we can. And so that is all a sort of a prefatory remark to say that I believe that, and the amendments that I recommended here acknowledge some of the very strong statements that you made about people who were trafficked here. The statute of limitations that we have offered, or that I have offered, extends that statute of limitations to 10 years. There are very few crimes where we allow a statute of limitations that long, not because we don't want to get the bad guys, but we recognize that people's memories, their ability to remember an incident, to identify the location, to bring justice to be heard, can be affected by that delay in time. And yet, given what we recognize with some of the egregious behaviors of trafficking and so forth, we want to be able to provide an opportunity for someone to come into a court of law, to have their day in court. Although I must suggest that because of delay, frequently it's difficult to get that justice because memories have faded, and so to prove a case beyond a reasonable doubt into a moral certainty becomes a question to a jury or a judge who's the trier of fact, whether or not that recollection is strong enough to create that kind of evidence for a conviction. So we have that issue. We have the issue for many of us, I think it's the first day of law school. The case of International Shoe, I believe it is. I know, and we say that, where we learn about the proper forum to bring a lawsuit. And I know, it still gives me hives to think about it, but that we learned that lawsuits should be brought by people within a jurisdiction who have a right to bring a lawsuit within a jurisdiction. That's why we ask that people be California residents. Not at the end of the day, but where particularly where the event occurs, and that they are residents of the state, so that they have the ability and the right, if you will, to proceed in our courts. We have federal courts and we have international courts of law where most of these crimes have been adjudicated. I happen to believe that is the appropriate place, particularly when we're talking about crimes of genocide, when we're talking about incidents where a lot of the testimony and the witnesses will be from other places. We have federal laws that also protect and that we have used to great advantage in dealing with cases where we have people who have been aggrieved and righteously seek their day in court. But to now say to California, we are going to open this up 115 years, the question then becomes, why not open it 250 years? Why not open it 400 years? Certainly, Native Americans were subjected to genocide, arguably to crimes for which they have never been compensated. Our African American brothers and sisters who were brought over as slaves. I mean, there's a point at which you have to ask, when are we doing justice and when are we not? And I think given the parameters of our legal system, which is a process as well as a result, that is at least for me the motivation why I've offered these amendments, but do not believe that we should open that door 115 years or allow people who are not California residents to come in and to establish jurisdiction so that they can bring lawsuits that they can't bring in their own jurisdiction because the statute has run. We opened this floodgate, and our entire system of justice, some might argue maybe we should blow it all up, but as the Judiciary Committee in the State Senate, I believe it is our duty to really do what we can to seek justice while preserving a system. And that is I think the explanation as to what my thinking has been on this, and I would certainly like to invite my colleagues if they have or would like to share their thoughts as well. Senator Hertzberg?
I just don't understand how I see the amendments to the sections in the measure. This is what I was going to ask you, Mr. Majority Leader. The issue about extending the statute of limitations, great. But then when we get to the issue that the chair is looking at, we look at section 2 and we go over to the final page 6, that section 2, lines 5 through 10. In other words, I don't understand mechanically how you do that. If somebody is okay at a minor and something happens to them at 2, they've got till 10 years after they're 18, so that's 28 years plus, deal. But how do you get to 115 years? I'm just trying to understand how the mechanics of the bill work. Because if you've got the statute of limitations, how would this actually have any meaning? I'd like to just get an explanation on that. That's what I don't understand. How do you go back 115 years if the statutes have to be brought, even if it's a minor? I don't understand how they weave. I don't know if someone could explain that to me.
Well, essentially, the revival provision, it's not based, obviously, on tolling or, someone being a minor at the time of the crime. It's a separate provision, basically recognizing that there have been these historical atrocities of the 20th century, the first modern genocide, where victims have never been able to have their day in court. So the bill specifically just provides a 2-year limited period where cases dating back that far will be revived. But beyond the 2-year period, those cases are closed forever, and then the 10-year statute applies.
I see. So when you say this section shall also be construed, it's really, here's one section that gives you a statute of limitations which is extended, which you're doing, and then it also extends the time if it's a minor, rather than, under the law, it changes it differently. And then, in addition, as a bolt-on, we're going to give you a one-time window to litigate these issues.
Exactly, yeah,
right?
The revival provision is separate from
And then how do you, the second question I wanted to address, that the chair addressed, is the forum shopping issue. There are a whole host of federal issues, and I am sensitive to the issue of the art on 100 years, the Schoenberg case. But how does a Fresno Superior Court introduce evidence of something that happened 100 years ago on the other part of the planet? How do the rules of evidence work? How does that work? I guess I just don't understand. There's special forms that we have the Holocaust after the war, the Armenian genocide, certainly an issue quite sensitive, a number of other issues that are important, but we have had forums to do that. How does a court or a court in Imperial County, because it's anywhere in the jurisdiction, to all of a sudden take this evidence and decide this kind of case? I don't understand how that happens. Any thoughts on that? I'm just thinking about the practical, because what's going to happen is if this measure gets signed into law, it will clearly, people have ideas. Clearly, there's people behind this, and you're going to invite litigation, and there will be litigation that will come as a result of this in some favorable court somewhere of the 58 counties of California in order to litigate a 100-year-old issue, and then we spend. How does that work? Just out of curiosity, you have any thoughts on that?
Yeah, as a practicing attorney, I would never accept a case that I didn't believe is meritorious or where the victim has a chance of recovery. It's not fair to the victims because they get their hopes up. These sorts of proceedings are very trying emotionally because they relive all these crimes. I think, Senator and Madam Chair, in the same way that evidence is scrutinized, needs to be authenticated for evidence which exists domestically, evidence obtained from foreign sources would undergo the same level of scrutiny. And if it's deemed inadmissible, it's not properly authenticated, it would be left out. And subsequently, I think the case would probably lack merit and wouldn't move forward. I think that would be my response.
Yeah, I think the important thing to note here is that AB 15 does nothing to change the standard in these cases. It doesn't make these cases any easier to win. It doesn't change, the level that you have to reach to have a meritorious claim. But just to add to what Heidi was saying, as a practicing attorney, ethically, you wouldn't want to bring a case that isn't meritorious. But even more importantly, in a practical sense, if you didn't think the case had a good shot of winning, and assuming most of these are going to be contingency fee cases, you're not going to bring in just for purely monetary, selfish reasons as well.
Well, then why don't you? Well, but that I don't necessarily agree with that. I see people bringing cases all the time. The standard for determining whether a case is properly brought or not is very different in our current jurisprudence. And people bring cases all the time for publicity reasons, to make points. I can give you examples in the city of Glendale, certainly with the Comfort Woman issue where the majority leader represents the area and the issues that they've had, where governments have supported these kinds of things. We've got a court system in the state that is badly battered with lack of resources. We don't even have interpreters. We don't even have stenographers in many instances. And now we're going to burden the court with generally, it seems to me, matters of international jurisdiction where you have language issues and translations and all kinds of stuff, where you have alternatives available in the system to deal with that, right? Don't you?
Actually, I don't think you do. Heidi can probably speak to, the Armenian situation, but more generally, the chairwoman mentioned federal law, and actually there are two main federal statutes that cover this type of behavior. The Torture Victim Protection Act, which covers torture and has since been expanded to also cover trafficking. And then there's the Alien Tort Statute, which is a lot more broad. You can bring in a lot of different types of human rights violations, except the Alien Tort Statute is only available to non-citizens. So all of these other kinds of claims, if they're being brought by U.S. citizens, there's no federal venue available for them. And, historically, wherever there are gaps in federal law, the state is left to, fill those gaps in, and that's pretty much what we're trying to do here. Right now, human rights claims just aren't brought at the state level because of statutes of limitation. That's the entire purpose of the bill. So we're not trying to, the 115 years is a separate issue, but as far as the bill itself.
Statute of limitations
Sure.
and its jurisdiction,
Mm-hmm.
right? You're giving jurisdiction here in terms of forum shopping. You've got the international shoe case to which the chair refers. It's all about jurisdictions. What's the nexus in terms of what happened, and how do you establish that? And how do you establish standing and all of those other issues? You're doing the two things that are necessary. I understand, as a lawyer, to one, say we've got standing, we've got jurisdiction, and two, we don't have a statute of limitations problem, so that you're availing yourself of the Superior Court of California for these kinds of cases that otherwise, even if you had a statute of limitations elimination, 115 years, you probably would not prevail unless you created jurisdiction, I would think.
Well, I think that's the important thing to note about this bill. It doesn't affect international shoe. It doesn't affect personal jurisdiction, any of these types of things to keep those kinds of claims out of the court. All it does is affect the statute of limitations or, revive these claims based on the statute of limitations. As I said, it doesn't make it any easier. There is the borrowing statute provision, which I spoke about. That, however, doesn't affect personal jurisdiction or venue, any of these other tools that courts have to throw out cases that have no nexus to California, they're all still intact with this bill.
Yeah, and just to add on, I think that the purpose of the bill is to benefit Californians and Californians only, and only with respect to actors and perpetrators that have benefited and either have sought a safe harbor within the state or have a clear nexus, whether it be an insurance company that does business here, that has issued policies in these foreign countries. I mean, as far as the availability of other remedies and different venues, unfortunately, international tribunals such as The Hague, the International the Criminal Court of Justice, there's very limited opportunity for individual claimants to seek remedies in those forums. And certainly the host countries as a whole are generally not going to be very amenable to claims of whether it's genocide or other crimes against humanity for claims to be filed within those foreign jurisdictions. I think for Californians, the best possible opportunity would be for this bill to be enacted. And again, it's going to be, particularly for past crimes, I think it's going to be a very narrow pool because of the lack of evidence in certain cases. As I mentioned, I wouldn't benefit personally. I don't have a claim to raise that I'm aware of related to this, and so it's going to be a narrow pool. But for those few, I think that could benefit. It could be.
But you are extending the reasoning in the case of McCann versus Foster Wheeler, where the case limits the cause of action. You are, to some extent, increasing the forum shopping. The point I'm trying to raise here, which, unless I didn't hear it correctly, the plaintiff who becomes a citizen of California after the cause of action accrued, but before the lawsuit in question was filed, where you're changing that standard so you, in fact, create the forum shop. You allow for that to occur. You're extending the ability of who the plaintiffs could be in the case, right? So when you say you're not extending international shooting, you are, in fact, changing those standards for purposes of allowing for forum shopping. I'm not objecting to it. I'm just trying to get clarity on it.
I think it, and I think it was
you know what I mean?
part of our. No, I get you on that, and I think what we in the testimony, one of our witnesses wasn't able to be here today, and certainly her situation follows into that example, and to that extent, we recognize that after the crime perpetrated against her, the human trafficking trauma that she went through, she then subsequently became a resident of California. And so therein lied a situation where she now lives here, she works here, she's trying to rebuild her life here, and this is an opportunity for her when she is stable enough and able to face some of the issues that, quite frankly, I think she's continuing to rebound from, that she has an option to be able to take her case up and to seek justice. And I think that's the kind of scenario we're looking at. And I think it's also, and I'll just cite that the legislature has been supportive in terms of the statute of limitations question, has supported similar efforts. So this is not going to be groundbreaking from that standpoint in terms of going back the 115 years, because we've extended the statute of limitations for abuses related to international human rights abuses. An example is in California, and I believe it was the Norton Simon Museum, where artwork was, the statute of limitations was extended for actions to recover a work of art from, I believe it's the Norton Simon Museum, which happens to be in the 41st.
Yeah, I noticed
that was unlawfully taken and stolen and revived all such claims over the past 100 years as a result. So we're sort of looking at not necessarily trailblazing with this particular provision, but we're recognizing too that human trafficking is a worldwide crime, and people, children and adults, are being taken all over the world from their place of residency, and sometimes they make it back and sometimes they don't. And to the extent that they are able to make it back, to the extent in our example with our witness are able to make it back and are able to get their footing and to start regaining some semblances of their life, and it sometimes takes time for that to happen. They're not ready to rush right into a court to identify a lawyer to then proceed through stated laws and timeframes, because their recovery doesn't necessarily fit with those stated times.
Which is why we proposed a 10-year statute of limitations, which is a significant extension. I mean, I can't think of that many areas where we have a 10-year statute. That is quite broad, and for the reasons that you've mentioned. So, which again,
one other thought on this.
Yes, please. Please.
On this, because I'm looking for jurisprudential consistency. I'm looking across all the codes and saying, what do we do as a legislative branch? Right, and I think this issue with respect to the Schoenberg case and some of the other things are instructive, and the museum in your district, Norton Simon, are instructive to some extent. And we do, in the marital dissolution field, allow people to move to California and take advantages of our courts, right? Someone moves here, they can say, well, now they've been here for 6 months, we have jurisdiction over the stuff, so you can dissolve your marriage, and getting the benefit of California's laws. But we don't have laws that say if somebody hits you in the nose in Mississippi, that you can then come to California and bring the person from Mississippi because the damage occurred in Mississippi. The only question here, and the final point, is the uniqueness of this issue in terms of its, is somewhat challenging in terms of how we do it. But I'm really, what grapples my mind in all of this stuff is we tend often to limit our view in the legislature to whatever the thing of the moment is, and it worries me a little bit. And I'm trying to take the longer view and say, okay, well, we have no statute of limitations for murder. What statutes do we have that fit where? If we're going to have exceptions, what are those rules? And then have a consistent jurisprudential approach. And so what grabbed my thinking in this and reading the analysis and even just quickly looking at the bill, I did not talk to the chair in any detail about this, is the two things that hit her, because we're both old-time lawyers, is the issue of the statute going back 115 years. How does that really work? And then the forum shopping piece, which basically, in a very unique way, affords California courts, which are just dying, and I don't believe that there will not be a bunch of cases that can be filed, and for a bunch of reasons, whether it's publicity purposes, whether it's historic, exposing the history or whatever it may be. And so it just proves a little challenging. I don't know what my conclusion is, but I wanted to kind of probe those issues. So thank you, Madam Chair, for letting me have so much time on this.
Thank you. Yes, Senator Wojtkowski.
the temptation to talk about Panoyer versus Neff or the twin aims of Erie are with me, but I'm going to control myself. And I think my colleagues have made, and reading the analysis, there are some legitimate legal reasons not to go forward with your bill. But I don't know enough about crimes against humanity, because my colleague is talking about this area of jurisprudence and how these systematic crimes, I read about it and I see the television, but I don't have an understanding of the injustice that I believe the author has, is that these are not like, one of Wachowski's debt buyer bills. I want to give people more time. This is a whole class of systematic torture, abuse, and if somebody becomes a citizen and they don't have a cause of action under the Alien Tort Act because they became a California citizens, so can you talk to me, educate me on the crimes against humanity? I mean, why is this such an important class of crimes and actions that California should open up its courts for a 2-year period in order to have as you said in your opening, allow these survivors of the conflict to have their day in court?